judgment, which says to initiate a war of aggression is not only an international crime, it is the supreme international crime, differing only from other war crimes in that it contains within itself the accumulated evil of the whole. In Kampala in 2010, the Review Conference adopted provisions which will allow the International Criminal Court to exercise its jurisdiction over the crime of aggression, expressly pledging its resolve to activate such a jurisdiction as early as possible. This accomplishment has been held in a historic landmark, both in international law and in the quest for global peace and security. Actually, for the first time in history, a permanent independent international court will have the competence to hold national leaders accountable for the most serious form of the illegal use of force against other states. The minimum of 30 ratifications are required to activate the court's jurisdiction over the crime of aggression, and will finally align the system of present-day international criminal justice with the principles established at the Nuremberg trial. The provisions of the Kampala amendments will only have their full effect if we ratify it. On several occasions, the European Parliament has strongly supported the ratification and entry into force of the Kampala amendments. In November 2011, we had passed a resolution welcoming the adoption of the Kampala amendments, including, of course, the crime of aggression. Then we had a resolution in April 2012, which recognizes the jurisdiction of the ICC over the 4 core crimes. And I think those of you who don't know it, you will find these resolutions in your dossier. Now, we are, of course, coming at the end of our legislature, but not as chair, but as a Green MEP, I have reached out to several other MEPs, and I hope I will find more. Perhaps before the end of the term, we managed to pass even a resolution this year, as it is 75 years after the beginning of the Second World War, to again underline the importance that we get much more ratifications as we have now, including ratifications from member states. But let's see how this works in the system, because we are a little bit late. Now, we have for the debate 2 speakers. We have Monsieur Gérard Dief from the Belgian Ministry of Justice. Welcome. Mr. Dive is the coordinator fédéral de la coopération judiciaire avec les juridictions pénales internationales, and the Belgian delegate to the Council's working group dealing with the International Criminal Court. This working group is named UYUR ICC. And also, Belgium has recently ratified the Kampala amendments. Now we have 7 EU member states: Luxembourg, Estonia, Germany, Cyprus, Slovenia, and also Croatia. And then we will hear from you on the crime of aggression in Belgian position. And then we have with us, who is known to us in the Parliament very well, Dr. Donat Katin from the Secretary General for the Parliamentarians for Global Action. Good morning, I assume, David.
Good morning. Good morning or good afternoon.
Good. Yeah, so we can hear and see you well. Thank you for the EU delegation for helping us to having this video message. So the Parliamentarians for Global Action, some of our colleagues are members in this organization. It has over 1,000 legislators in approximately 130 elected parliaments around the globe, with the aim of promoting peace, democracy, the rule of law, human rights, gender equality, and population issues by informing, convening, and mobilizing parliamentarians to realize these goals. So I assume, David, you brief us where we are at the moment with this Kampala amendments and the crime of aggression, and perhaps also to hear from you what we could do to support the strengthening of the ratification process. Please, the floor is yours.
Thank you very much, Madame Lochbihler. These amendments that were adopted in Kampala have been already widely commented, and as you have already noticed, a lot of action has been undertaken. The status of the ratification is 13 as of today, and the requirement for entry into force is 30. However, the activation of the jurisdiction may take place only after 2017, at a point in time in which there will be a meeting of the state parties, and 2/3 of the state parties will be required to give a positive vote to the activation of the jurisdiction. So it is extremely important that, given that at that point in time the jurisdiction will only start the 1 year after the deposit of the 30th ratification, that we arrive by the end of 2016 with the 30 ratification, so that from the 1st of January 2017, when it's allowed to organize this conference of the state parties, as soon as the decision of the state parties may be taken, the jurisdiction of the court will immediately start. Now, the jurisdiction of the court can operate in two ways. One is based on state consent, and one is based on decision by the Security Council under Chapter 7 of the United Nations Charter. The second avenue is not problematic at all, because, as we know from the past interventions of the ICC regarding Libya and regarding Darfur, it can extend to any situation affected by international crimes. What the Security Council will be empowered to do, should the state parties activate the jurisdiction of the court, and should we reach this quota of at least 30 ratifications by 2017, what the Council can do is just refer a matter to the court, and the court will then look into the situation, make investigations, and independently decide whether war crimes, crimes against humanity, genocide, or the crime of aggression can be brought to justice before the court itself. But what we are discussing now is the importance of ratification. Ratification instead allows that each of the member states, the 122 member states, would be protected also by this crime. This crime was already penalized, criminalized at the time of the Nuremberg judgment. So in 1945, on the basis already of a declaration, the Moscow Declaration of 1943 of the Allied Powers, in which it was clearly stipulated that the most serious perpetrators of atrocities of World War II should have brought to justice, including the waging of aggressive war. Therefore, we had the Nuremberg tribunals, the Nuremberg precedent is the basis of contemporary international law, and what we are doing now is filling a gap that was left empty since that time that impeded the development of public international law in this realm due to the emergence of the Cold War that froze the development of international law. Now, if it was good and legitimate to try and prosecute individuals allegedly authors of the crime of aggression in 1945, I see no reason why it shouldn't happen also now. However, there are controversies surrounding the Kampala Review Conference amendments. And in 2011, the European Union revised the common position of 2003 regarding the ICC, which is a fundamental tool to promote the universality and effectiveness of the Rome Statute system, and makes the European Union the leading international organization, the leading entity in promoting and defending the ICC worldwide. So on behalf of Parliamentarians for Global Action, but also on behalf of the global civil society community, I must say that the EU role is absolutely essential. Nevertheless, the EU failed, or did not decide, let's put it in the non-negative way, did not decide to include the Kampala, the ratification of the Kampala amendments in the revised position. This is because there was a controversy, and there is still a discussion relating to the to certain implications of the definition adopted in Kampala, and above all, to the conditions for the exercise of jurisdiction of the court. Here we had, and I put everything in a paper that I made available to you, to your committee for distribution, so that everything is put in a very clear way. But in substance, you had two negotiating positions back in 2002 when the Rome Statute entered into force in the negotiations that led to the 2010 Kampala Compromise. You had the permanent members of the Security Council calling for their exclusive prerogative to determine that an aggression had occurred under Article 39 of the United Nations Charter. As we all know, under Article 39, the United Nations Security Council has the exclusive authority to ascertain whether an act of aggression, a breach to the peace, or a threat to the peace occurred, so to trigger the powers under Chapter 7 that allow the Security Council to take measures to restore international peace and security. No one questioned that fundamental and exclusive authority of the Council. But a majority of other states said, notwithstanding this very important prerogative of the Council, the decision regarding whether a crime of aggression was committed as far as the individual responsibility of the perpetrator was concerned did not belong to the Council, and does not, in fact, belong to the Council under the UN Charter. And so there was the need to find a way for the Council not to be the dominus of the proceedings before the court, not to politicize the court. And a compromise was found in Kampala, so that when a situation arises that the prosecutor of the ICC would believe that a crime of aggression has occurred, he or she can ask the Council for 6 months to evaluate the matter. But if the Council does not make any determination within 6 months, the prosecutor is allowed to request an authorization to proceed with investigations by the full pretrial division composed of 5 judges. After that, the judges would have decided in that direction, then the prosecutor of the ICC could start will be able to start an investigation under the Kampala terms on the crime of aggression, provided, however, that he or she has jurisdiction on the basis of the consent of the ratifying state. In other words, you need to find out whether the act of aggression was committed by a state that had accepted the Kampala amendment in terms of positive ratification, or if it was, or if it is a non-state, a state party to the Rome Statute and has not ratified, a state that has not opted out from the jurisdiction of the court on the crime of aggression. It's quite a complicated scheme, but it seems to me, but we will see in the next years if this controversy will be resolved, it seems to me that those states, parties, including permanent members to the UN Security Council, that will not want to be bound by the amendment, will still have the ability to send a letter to the registrar of the ICC explaining the reasons why they don't want to be bound, and that would be interpreted as if it was an opt-out declaration. So in other words, I believe that there is already on the table, and the facilitator of this negotiation, the government of Liechtenstein, also put it on the table as an option. I think there is on the table a solution to the controversy that stemmed out of Kampala regarding certain states that do not want to be bound by the amendment. The amendment, therefore, will be binding for everyone if the Security Council will send the situation to the jurisdiction of the court, but will only be binding for ratifying states, being victim states and or aggressor states, if the prosecutor will exercise proprio motu its authority after having waited 6 months of Security Council intervention and after having obtained a positive authorization by the judges of the pretrial division. So you see the checks and balances, you see the controls, you see the impossibility of the prosecutor to, let's say, abuse of the power that the Rome Statute is entrusting with him or her. This means, and I conclude, that the ratification is more and more important. This is a consent-based jurisdiction. So we need as many states as possible to agree to the principle that the most serious violations of international law, I use Cogen's prohibition, the prohibition of the use of illegal armed force, is an international crime when it is in manifest violation of the UN Charter as defined by the amendment to the Rome Statute that they are called to ratify. The definition is very simple, it's very clear. It does not allow gray areas, multilateral operations with certain humanitarian purposes upon request of the territorial state, as in the recent case of Mali or Central African Republic, which were then sanctioned and authorized by the Security Council under Chapter 7. All those situations of lawful armed force, lawful exercise of armed force, are excluded, of course, from the definition. And also mixed use of force are also excluded, because you have a chapeau of the definition that make it absolutely clear that the perpetrator who is a person in a position effectively to exercise control over or direct the political or military action of a state must have committed a violation of the United Nations Charter, regardless of a declaration of war, that must be, by its character, gravity, and scale, a manifest violation of the Charter itself. So all these caveats ensures that mixed situation, gray zones, will not be taken up by the ICC. We are really talking only about the scenarios that we have learned, unfortunately and tragically, in World War II, or other situations where there have been blatantly unlawful invasions, attacks, bombardments of other sovereign states without any legal justification. Many European Union states have decided or are deciding to ratify the amendment. My humble advice, if I'm allowed to give it, would be for the EU as such, and not only for individual member states, to move forward in this important direction. I stand ready to respond to any question, and I look forward to the possible resolution, Madam Chairperson, that you have referred to. It is very important that before this Parliament ends, this Parliament, I believe, had the most impressive track record on human rights that we have seen in the 30 years of history of the European Parliament. I believe your annual report on human rights are the most important document of reference that comes from Brussels, in our point of view, from civil society, to guide our work on so many issues. And the fact that you have not excluded the crime of aggression, that you have included this supreme crime within the list of those that causes enormous suffering and therefore enormous violations of human rights in your priorities, is really something that we are very grateful for. Thank you very much.
Thank you, David Stonat-Katin. We will hear now our second expert, and then from the ERS, and then at the very end you can also have the floor. Now, Mr. Diebe.
Thank you, Madam Chair. And first of all, thank you for inviting me to this meeting. It's always a pleasure for a representative of Belgium to intervene on the matter of the amendments to the Rome Statute, obviously also on second amendment, the one related to